This is Lecture 1 for Class 7. In this lecture, we are going to go over some background material and then review the parts of the case that can help advance your case law research. Your case law research must reveal the governing legal principles at issue. When you start your case law research, try not to get in the habit of trying to match all of the facts of your case to facts in other cases right from the start. It's unlikely that you will be successful in that regard. Instead, think more about using the keywords that describe the legal issue rather than the actual facts of the case. Once you have your legal principles reflected in your cases, you can then focus on cases with similar facts in order to make your analogy or to distinguish the line of cases representing the law on that issue. You are trying to find cases whose facts are similar to your own case and should be controlling. We call that reasoning by analogy. For example, the wheel of a bike is substantially similar to the wheel of a car. But you may also argue that a line of cases is sufficiently dissimilar so that it is not controlling, in which case you argue that the facts are so dissimilar that a similar outcome should not be the same. For example, the wheel of a boat is not the same as the wheel of a bike. In the latter situation, you must distinguish your case from cases that reach the opposite result. Here are 5 recommended ways to begin your case law research. You have a statute, and you can look up the code section in an annotated code to review the notes of decision or the key citing references. If you already have a citation or the name of a case that you read about in a secondary authority, you can use that case as your jump-off point. You can also find a case from reading another case. You can conduct keyword searches about the legal issues that you are researching on a database like Westlaw Next. And you can use the Westlaw key number system, either on its own or in conjunction with any of the above. Before we start to learn how to search for cases in a systematic way, we need to stop and be sure we know all the relevant parts of a case, because they can be searched individually, making your research a more rewarding experience. As a whole, a reported case has many components and looks like this one, Hicks v. State, that was published in the Southwestern Reporter in 1976. This is a representation of the official case reporter that has this case printed in it. As a point of interest, most cases are unreported, meaning that they are not published in a reporter of record for the court. Decisions that are selected for reporting are those which make new law or are of general interest to the public. You can find unreported decisions online, but their precedential value will vary by jurisdiction. For example, the Ninth Circuit will not recognize unreported decisions as having any precedential value. Courts have rules about the conduct of a trial, and you need to check the local court rules for each jurisdiction to know what is allowed and what is not allowed. When you are reviewing the case law to support your analysis, you have to keep in mind where the case is coming from. If the case is from a court not within its line of appeal, the case has only persuasive authority. However, if it is from a court within its line of appeal, the case has the stature of mandatory authority, meaning the reasoning and holding should be followed unless your case is distinguishable in some way. We've looked at the line of appeal in Hawaii and at the federal level already, but let's review it quickly to refresh your memory and talk about where the cases are reported. Here is a chart of the Hawaii judicial system. In many state and local jurisdictions, the cases are not reported at the trial level. And this is true in Hawaii. With the use of online technology, courts around the country are posting their materials on their web pages, and in fact, Westlaw is including those unreported cases in their database. But this is distinctly different than reporting a case. A reported case is selected for publication, and not all cases, in fact most cases, are not published. The Hawaii Appellate Courts, the Intermediate Court of Appeals, and the Supreme Court of Hawaii share the same case reporters, the Hawaii Reports and the Pacific Reporter. We looked at these in the first and second weeks of class. At the federal level, selected trial-level decisions are reported. Even the specialized courts report their decisions. The way authority works is that an opinion is binding on itself and lower courts in the chain of command. So here, the Federal District Court of Hawaii presents mandatory authority only for itself and not for other federal districts or the courts where appeals might be taken. Likewise, Ninth Circuit Court of Appeals are binding only on itself and the district courts from where it hears appeals. And then the Supreme Court presents mandatory authority on the courts below. We're reminded here that the Federal District Court opinions are found in the Federal Supplement series. The Courts of Appeal decisions are found in the Federal Reporter series. And the Supreme Court of the United States publishes its official opinions in the U.S. Reports and unofficially in the Supreme Court Reporter. Remember to check Table 1 in your Blue Book, which can help you identify the different courts in each jurisdiction, and also where their decisions are reported. For example, in Table 1, we see the current opinions from the Federal Claims Court are published in the Federal Claims Reporter. Right above this entry, we see the entry for the U.S. Courts of Appeal for the Federal Circuit, which is identified as the Appellate Court for the Court of Claims. What we are leaving out of our discussion is when federal courts hear state law cases and vice versa. This is a complicated issue, best left to your civil procedure or federal courts classes. For now, let's just focus on the basics of jurisdiction and the lines of appeal that represent mandatory authority for you. A case has different parts to it. Some are more helpful than others for research. So I want to identify the usual elements that make up a reported case. In our example of Hicks versus State, I'm going to dissect the parts of the case because each part can be used to advance your case law research. The first part is the title, or the case name. This designates the parties, such as Hicks versus State. Depending on the nature of an action, there may be only one party, such as In re Pimsleur, or the matter of Cohen. Or it may be an action like this one that includes the government, Hicks versus State, a criminal case. Usually there are two private parties, such as Dole versus Outrigger Hotel. The plaintiff-defendant order is usually kept throughout the case. However, in some courts the order is reversed on appeal when the defendant in the court below has lost and becomes the appellant. The docket. The docket information, which is the filing number assigned to the case when the complaint is first filed, and serves as the case's tag. It is a convenient way to find cases filed, especially if the case is pending and there is no opinion yet issued for it. The date of the case is the date that the decision was handed down. A syllabus or synopsis. A syllabus is a summary of the case's facts and court's holdings. In West Publications, the syllabus is called a synopsis. This contains the important issues and facts of the case. A headnote. Headnotes serve as an index to the case itself. Headnotes are made up of brief statements of the law involved in the reported case. It may address a pure statement of legal principle or may contain factual information that is tied to a legal principle. You will notice that each headnote has a subject heading. This is called a digest topic. It's followed by a little key symbol that's difficult to see on this representation, and then a number. The number is known as a key number. This subject classification represents the West Digest topic and key number system, which we will look at in more detail in the next lecture. A case can have many headnotes, or only a couple as in this example. These are headnotes number 1 and number 2. and are directly related to where in the opinion these issues are discussed. This is an excellent way to skim through a case to see if you need to thoroughly review it. Attorneys. A case reporter will usually indicate who the attorneys were representing the parties. The judges who heard the case. The trial level will typically only have one judge who hears a case and writes the opinion. Appellate level cases usually consist of a panel of judges who hear the case, but one judge is responsible for writing the opinion. And you are given the name of the judge who wrote the opinion directly before the statement of facts. The statement of facts reviews the facts for the current case. Following the statement of facts is the opinion. In the opinion, the court explains the reasoning behind its decision or its holding. Note that there may be more than one opinion if the case was heard by a panel. Concurring opinions are offered when the concurrer agrees with the outcome but not altogether with the reasoning leading to it. There may be a dissenting opinion, which represents the minority's statement for its reasons for disagreeing with the majority. There are also per curiam decisions that report routine decisions and often lack any statement of reasoning as to why the court arrived at its decision. The per curiam decisions have somewhat diminished precedential value because of these factors. See the little 1 and 2? These numbers relate back to the headnote numbers. There are only 2 headnotes, and the issues that the headnotes describe are both found in this single paragraph. And then there is the decision of the court. This is what the court does, as distinguished from what it says in the opinion. All of these parts make up the whole of a case as you see it here in this single one-page decision. You can leverage the Westlaw Next database using the parts of the case to retrieve better sets of cases. We're going to look at the headnotes more closely in the next lecture. This concludes Lecture 1 for Class 7.